Good afternoon, Your Honor. Marie Taylor on behalf of the Office of the Public Defender.
Good afternoon. And for the state, do we need to put that appearance on the record as well?
Yes, Your Honor. Travis Tarpey for the state.
And for pretrial release?
Yes, Your Honor. Officer Guerra representing pretrial release.
Okay, thank you, everyone. And we have the interpreter on the line. Sir, would you state your name for the record?
Eric Joel Negrin Perez.
Eric Joel Negrin Perez.
Okay, Mr. Negrin Perez, you are here on a first appearance on the charge of violation of condition of pretrial release. There are two of those charges.
Can the interpreter say something so we can tell if the headset's working?
Sí, ahora sí.
Okay, we're good.
The defendant can hear me.
Okay, thank you. Sir, anything that you say today may be used against you. You have the right to communicate with counsel, family, and friends, and accommodations may be made to assist you in doing so. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today?
No,
No, do you have your own attorney, sir?
no.
No.
He has a public defender. Does your office represent him, ma'am?
We may on another case, Your Honor. I don't have a note. But if Madam Clerk says we do, then I'm sure we do.
Think on the underlying charge? Okay, so I will not appoint a new attorney to represent you. It does look like you're already represented by counsel, but we don't have the attorney here today, do we? No, okay. Okay, sir, at this time, I am finding probable cause to support the charges of violation of pretrial release. Would the state like to be heard on bond?
No, Your Honor. No recommendation.
Pretrial release, would you like to be heard? No? Okay.
Judge, so I think what happened on this one, he was released on PTR, and then when he showed up to the check-in, they found a piece of ammo in his bag in the x-ray machine, so they violated him. But it's not technically a new law violation, it's just a violation of the conditions of his release. So I would just ask the court to kind of take no action on the violation, but set a monetary bond instead of holding him no bond, because there's not actually a new law violation.
State?
No, the state would have no objection to that, Your Honor. We'll leave it to the court's discretion.
Okay, at this point, I am going to revoke the pretrial release and hold him without a bond. I'm finding that he has there's probable cause to support that he has violated the conditions of a prior order of the court. Let's see, okay.
Oh, can the interpreter repeat the judge's order, please? Okay, all right, thank you.
Thank you. Have a nice day, sir. Okay, the next case is Vincent Cinto Mendez.
That's it for today.
Good afternoon, sir. Would you please state your name for the record?
Mi nombre es Víctor Vicente Méndez.
Mr. Cinto Mendez, you are here for your first appearance on the charge of DUI and damage to property or person of another, and for a traffic violation. You have the right to remain silent. Anything that you say today may be used against you.
Ajá.
You also have the right to communicate with counsel, family, and friends, and accommodations may be made to assist you in doing so. You have the right to an attorney, sir. Would you like me to appoint the Office of the Public Defender to represent you today?
Si lo puedo hacer aquí mismo.
If I can do it right here,
I can appoint the Office of the Public Defender to represent you right here. Would you like me to do that?
Bueno, sí, sí, se puede, pues, sí.
yes, if it's possible, yes.
Okay, at this time, I will appoint the Office of the Public Defender to represent you. In addition, based on what I have reviewed, I am finding probable cause in this case. Would the defense like me to consider anything before I set bond?
Just that Mr. Vicente appears to have a very minimal criminal history.
Okay, thank you for that. Pretrial release, anything? Okay, at this point, let me find the charges, one moment. At this point, I am going to set bond in the amount of $1,000 on both, on count one and $1,000 on count two. In addition, I'm going to find that you should use no alcohol. Have a nice day, sir.
Okay.
The next case is Brian Ortega.
Ay, sorry. Sorry. Again, nervous, sorry.
Sir, will you please state your name for the record?
Brian Ortega.
Ryan Ortega.
Mr. Ortega, you are here for a first appearance. It looks like you have a warrant out for you in a different county. Let's see,
It's Seminole.
in Seminole County, thank you. There is a warrant out for your arrest in Seminole County. At this point, I am finding, whoops, I think I'm getting ahead of myself here. Sir, you have the right to remain silent. Anything you say today may be used against you. You also have the right to communicate with counsel, family, and friends. And I can make reasonable accommodations to assist you in doing that. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today?
No lo entendí a usted, señor.
I didn't quite understand.
No.
Would you like me to appoint the Office of the Public Defender to be your attorney?
Pero, ¿qué fue lo que yo hice?
Well, what did I do?
You are here, sir. The original offense was resisting an officer with violence, and there is a warrant out for your arrest in Seminole County.
¿Desobediencia a qué?
Resisting towards what?
Resisting a police officer with violence is the charge, sir.
Oh. Right.
Judge, I think usually on the out-of counties, we're not appointing the PD anymore since transport has picked up again.
And they're going to get him, okay. At this point, there's no bond issued on the other warrant. So we will, they will come and pick you up on that one. Have a nice day, sir.
Judge, should I, oh, I'm sorry.
Okay.
He speaks Portuguese.
Okay, do we have a Portuguese interpreter on the line?
But the victim needs Spanish.
Okay, I have the Spanish interpreter on the line.
And while we're doing that, Judge, I didn't know if you wanted me to switch off and let private counsel address his cases, or if
Sure, that'll be
doing
fine.
that now.
Okay.
Oh.
Can the interpreter hear me?
Yes, hello.
Yes, Your Honor.
Portuguese interpreter.
Okay, there is a Portuguese interpreter on the line as well that needs to be sworn in.
Just raise your right hand. Do you swear to translate from Portuguese to English, English to Portuguese, testimony is given?
I do.
Okay, the next case that I have listed is Rodrigo Desu Demeter. I apologize if I'm mispronouncing your name, sir.
Próximo caso que eu tenho é Rodrigo de Souza Maria, e eu peço desculpa se eu...
Sir, will you please state your name for the record?
Você pode, por favor...
Rodrigo
reparar
de
seu
Souza
nome?
Detmer.
Okay, sir, and you are here for your first appearance, and you have been charged with battery of domestic violence.
Yes, ma'am.
O senhor está aqui para seu primeiro aparecimento e você foi acusado de
Judge,
agressão ou violência doméstica.
Oh, I see the problem.
I think,
He needs Portuguese.
He understands.
Can you understand English, sir? Okay. You're here for your first appearance for the crime of battery of domestic violence. You have the right to remain silent, and anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends, and reasonable accommodations may be made to assist you in doing that. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you?
I'd like to have a lawyer.
O senhor está aqui no seu primeiro
So I can appoint the Office of the Public Defender, the attorney standing next to you, to represent you today? Okay,
Do he need an interpreter?
he does not.
So the Portuguese can hang up? He doesn't-
Yes, could our Portuguese interpreter, it appears he does understand the English language, so we're not going to need the Portuguese interpreter at this time. Thank you, though. We will need the Spanish interpreter.
Thank you, Your Honor.
Okay, thank you. At this point, I will appoint the Office of the Public Defender to represent you. I have found that there is probable cause to support the charge in this case. Ma'am, would you like to be heard?
Señora, ¿desea decir algo?
No, yo simplemente estoy acá para hacer la petición de
Let's,
motion de...
one moment, ma'am. Would you please raise your right hand to be sworn?
Un momento, por favor. Primero levante la mano derecha para prestar juramento.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Jura o promete que el testimonio que rendirá será la verdad, solo la verdad y nada más que la verdad.
Sí, yo juro.
Yes, I do.
Please state your name for the record, spell your last name.
Diga su nombre, por favor, y deletree su apellido.
Sí. Carmen Rojas es apellido R-O-J-A-S.
Carmen Rojas, R-O-J-A-S.
Okay, thank you. State, would you like to inquire?
Gracias. Fiscalía, ¿alguna pregunta?
Yes, ma'am. Are you concerned that an incident like this could happen again?
Señora, ¿siente usted alguna preocupación de que algún incidente como este pueda ocurrir otra vez?
Sí.
Yes.
No further questions, Your Honor.
Okay, ma'am, is there anything else you would like to bring to my attention?
Señora, ¿hay algo más que usted quiera decirme?
Solicitar ¿cómo se llama? El aislamiento o el distanciamiento.
To request, what is it called? The distancing or the keeping away thing?
No contact?
Correcto,
Una prohibición de contacto.
correcto. Y si es necesario tener que ir de nuevo tener que ir a corte el lunes para hacer esa petición.
Correct. And would I need to go to the courthouse on Monday to request that again?
I can enter an order as to no contact today, but there will be additional proceedings in front of another judge.
Yo puedo emitir una orden de prohibición de contacto hoy, pero sí habrán otras audiencias y diligencias más adelante con otro juez.
Okay.
Okay?
Okay.
Okay, would the defense like to be heard? Or sorry, did the defense want to inquire?
No, Your
¿La
Honor.
defensa tiene
Okay.
alguna pregunta? No, su señoría.
Would you like to be heard on bond?
Your Honor, it appears he has no prior history, so we'd request a minimal bond. He also has a below-average risk assessment according to the PTR paperwork. I would just request a one-time return with law enforcement to the property.
Do they live together?
It appears they do.
Okay. So at this point, I am going to set bond in the amount of $5,000. Direct that you have absolutely no contact with the victim. Not telephonic, not physical, not social media, no contact whatsoever. Do you understand that, sir?
Absolutely.
Bien,
And it-
señor, se emitirá una fianza de $5,000. Se le prohíbe el contacto con la víctima de ningún tipo. Nada de por teléfono, ni por mensajes, ni por redes sociales. Cero contacto.
I am going to allow you to return to the residence at one time, being accompanied by law enforcement in order to gather your belongings. You should not coordinate that visit with her.
Se le permitirá regresar a la residencia una sola vez junto a las autoridades para recoger sus pertenencias. Eso debe hacerlo con las autoridades. No puede contactarla a ella para arreglar esa visita.
You may not have any firearms. You may not consume any illegal substances.
Se le prohíbe la tenencia de un tipo de arma o arma de fuego y el uso de ninguna sustancia controlada.
Have a nice day, sir.
Your Honor, we did qualify Mr. Detmer for straight pretrial release. He has no priors. We did qualify him.
Okay? State?
Your Honor, I would leave it to the discretion of the court, given advice from pretrial.
Okay, I will release you on pretrial release, but keep the bond amount at $5,000.
Okay.
Have a nice day, sir. Thank you for coming, ma'am. Have a nice day.
Thank you.
Gracias, señora. Tenga un buen día.
Okay, and then I don't know which case is yours, sir.
Judge, I have two cases, Your Honor. The first one is Mr. Conti.
Okay, I have him right here. Mario Charles Conti.
Yes, and that's Ashley Parker on behalf of Mr. Conti.
Sir, would you please state your name for the record?
Mario Conti.
Oh, one moment, please. I think we can release the interpreter, yes? Okay, thank you for your assistance. We no longer need an interpreter at this time. Okay, Mr. Conti, you are here for a first appearance. The charge is aggravated stalking and cyber stalking after an injunction. You have the right to remain silent. Anything you say may be used against you. You have the right to communicate with your counsel, with your family and friends, and I can make reasonable accommodations to help you to do so. I see that you have your attorney here. I have found probable cause in this case. Would the defense like to be heard on bond?
Yes, Your Honor. I spoke to the state. I believe that they're willing to stipulate to a $5,000 bond in this case, Your Honor. Mr. Conti, as you can see, has no criminal history. He's the executive director and founder of the Hurricane Junior Golf Tour. He has substantial ties to the community, and he is not a flight risk.
State,
I would confirm, Your Honor, we did have that discussion today.
pretrial release.
No, Your Honor.
So it's after, so this is a violation of a current injunction, is that correct?
Yes, Your Honor. I believe based on the arrest affidavit, it's more of a possible violation of an injunction than stalking. This is a unique case where the underlying injunction that was entered is not a no contact order, it's a no hostile contact. So he is permitted to have contact with the victim. The allegations in the arrest affidavit, what they're alleging is that the contact is hostile, and they're alleging it rises to the level of stalking. I would strongly disagree. A lot of the communications are from last year, I believe last November and July. Most recently, the there was one text message recently that I don't even believe was directed towards the victim. So I strongly disagree with the finding that it is aggravated stalking. At most, it appears to be a violation of the no hostile contact agreement.
Was there a general no contact order already in place?
There was originally, Your Honor, it was modified to be no hostile contact for him to have contact with, I believe it's his ex-wife. So it's no hostile contact in the injunction. So he is again permitted to have contact. They're alleging that some of the messages that he sent would violate the no hostile contact agreement.
And I've reviewed them. Okay, at this point, I will enter bond in the amount of $5,000 as the parties discussed. I am further ordering that there is no contact. You may not contact this victim whatsoever. Telephonic, text messages, physically, social media, no contact whatsoever. You certainly you don't live there. Let's see, you are to have no firearms and to consume no illegal substances. Do you understand that, sir?
Yes, ma'am.
Okay, have a nice day, sir.
Thank you. Just so it's clear, he was not ordered pretrial release, just straight bond with those conditions, correct?
Correct.
Thank you, Your Honor.
And your next case is
It's
what?
Nicholas Burns. I believe it's number 5 on the list.
Where's it located?
See a battery? See.
I believe it's a battery. I have the,
DV. Oh, okay. He's a misdemeanor DV.
Number 5.
Thank you. Okay, sir, would you please state your name for the record?
Nicholas Burns.
Okay, Mr. Burns, you are here for a first appearance on the charge of battery. You have the right to remain silent. Anything you say may be used against you. You also have the right to communicate with your counsel, with your family and your friends, and I can make accommodations that are reasonable to help you do that. I see that your attorney is present today. At this point, I have made a finding that there is probable cause to support the charges. Defense, would you like to be heard on the bond?
I would, Your Honor. I
Oh, I'm
understand.
sorry. I'm sorry. Oh, thank you. Okay, I'm sorry, ma'am. Would you please raise your right hand to be sworn?
Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record, spell your last name.
Nicole Camacho.
Spell your last name.
Spell it. Camacho.
State, would you like to inquire?
Yes, Your Honor. Ma'am, are you currently concerned that this type of incident could happen again in the future?
Absolutely not. I wish to drop all charges. This incident was brought up by old past experiences with other relationships. He has never harmed me and never will harm me, and I'm very confident in that. He's never even I haven't even heard him raise his voice in my entire relationship.
Thank you.
Yes, thank you.
Defense?
Ms. Camacho, you would like to have contact with Mr. Burns?
Absolutely.
And you feel safe having contact with Mr. Burns?
Absolutely. I need him.
And you actually told law enforcement when they responded that a battery never occurred. Isn't that true?
Yes,
Okay, nothing
exactly.
further. Thank you, Your Honor.
Is that in the charging affidavit?
Yes, Your Honor. And I was going to make an argument to the court based on Florida statute 784.03. Battery requires actually or intentionally touching or striking someone against their will or causing bodily harm. Based on my review of the arrest affidavit, there's nothing that would qualify for that statute. There was no touching or striking against her will. There's no evidence that he caused her any bodily harm. So we would ask the court to not find probable cause, release Mr. Burns' ROR on his own recognizance. What Your Honor is referencing is, I believe it's the third line up from the bottom. It says it should be noted Ms. Camacho stated after the arrest that she lied. She attempted to take back her statements to Officer Killian and also wanted to be placed under arrest.
Okay, did you want to be heard on bond?
Judge, we'd ask the court to ROR him again based on the fact that there's no probable cause for his arrest. He has no prior criminal history. no prior arrest. The alleged victim has testified that a battery did not occur. We'd also like the court, if you are going to order a bond and conditions of release, that he be allowed to have contact with her. They do reside together, is my understanding. But again, you've heard from her that there's never been any previous violence in their relationship, and no battery occurred. I guess this was last night.
Okay, at this point, I am going to set a bond. I did find probable cause. You can make that argument to the next judge. I understand the argument. At this time, I am going to set bond in the amount of $1,000. I will allow you, based on the statements that I've heard today and the conflicting statements in the affidavit, to have contact with him. But sir, you are to consume no drugs, no illegal substances, and you are to consume no alcoholic beverages. Do you understand the rule?
Yes.
In addition, you are to have no firearms. Have a nice day, sir.
Ms. Camacho, if you want to speak with me, I'll be out front in a few minutes.
Oh, yes. Sorry, sir, please come back. In addition, you are to have no hostile contact with the alleged victim. Do you understand?
Yes.
Okay, so I'm allowing you all to be in the same area together, but you may not yell at her. There may be nothing hostile.
Understood.
Have a nice day, sir.
Judge, that's all I have. Thank you for taking my
Thank you.
case out of order. Have a great day.
You too. The next case is Jarvis Jamil Jackson.
Yes, Ann. Yeah, I approached. Quick. Shut down.
Is he here?
Yes.
Okay. Good afternoon, sir. Would you please state your name for the record?
Jarvis Jamil Jackson, and good afternoon, everyone.
Good afternoon. You're here for a first appearance on the two charges. The first is robbery with a firearm, and the next is possession of a firearm by a convicted felon. You have the right to remain silent. Anything you say may be used against you. You also have the right to speak with counsel, with family and friends, and accommodations can be made to assist you in doing so. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today?
Yes, ma'am.
Okay, at this point, I will appoint the Office of the Public Defender. In addition, I am finding that there is probable cause based on what I've reviewed to support the charges. In addition, I see that you are charged with a felony that is punishable by life, that being robbery with a firearm. I'm going to enter no bond on that charge, and I'm going to enter a bond of $50,000 on the charge of possession of a firearm by a convicted felon.
May I be heard briefly, Your
Yes.
Honor? I recognize the charge is a punishable by life felony. Defense's position is that the state has a burden to establish that there's proof evident presumption great as to the charge. So my first argument is the state has not done that. And secondly, if the court does find proof evident presumption great, we would just request that the court exercise its discretion in setting a bond anyway.
Okay, thank you. State?
Yeah, the state would rely on Thorman v. Jr. of the 3rd District Court of Appeals, where,
Do you have a citation?
yes, 275 SO.3D 726.
Thanks.
Can you tell me the holding that you're relying on, counsel?
Yes, Your Honor. Found that the section of the Florida Constitution establishing the right to pretrial release on reasonable conditions does not prohibit the trial court the discretion at first appearance upon a finding of probable cause that the defendant committed a crime punishable by capital punishment or life imprisonment, to defer ruling on bail and to detain the defendant for a reasonable time to conduct a full Arthur bond hearing.
So he can be detained without the Arthur hearing.
Yes.
Okay.
What I'm saying is that he may be detained for an Arthur hearing in the future.
Based on the probable cause that I'm finding
Based on
in
probable cause
the,
that you're finding today, yes.
any rebuttal, ma'am?
Candidly, Judge, what year did that? I'm not familiar with the case. That
Yes.
very well,
About 2019.
that very well may
I think
be the
there's a
case.
district split.
Okay, so
Is anyone aware of whether the 5th District Court of Appeal has spoken on the issue?
I'm not aware of that, Your Honor, but
I don't think it has. My understanding from, I think it's either the 2nd or the 4th, says that the state has to show something to establish proof evident presumption great, even at IA. So in the event of a split, I guess Your Honor just gets to decide.
Well, that's correct. But I do think that based on a review of what I have, a review of what has been submitted to me right now, I am going to find proof evident and presumption great, but I am also going to require that a future Arthur hearing be heard on that issue. So I am going to find that there is no bond and that there's a $50,000 bond on count 2, but that the Arthur hearing should be reviewed by a judge in the future as well.
Great, thank you.
Have a nice day, sir. Sorry? Oh, I'm sorry. The conditions on as to count 2 will be that you consume no illegal substances, that you have no firearms, and if you have any firearms, that you immediately surrender those to law enforcement, and that you are to have no contact with any victims. Have a nice day, sir.
No, that'll happen the same time as the Arthur hearing.
The next case is Willie Williams.
Approaching Your Honor.
Thank you.
you can, I mean, unless.
It's your own copy.
Okay.
Would you state your name for the record, sir?
Willie Williams.
Good afternoon, Mr. Williams. You are here for a first appearance, and the charge is failure to appear. The original offense, it looks like, was possession of cocaine. You have the right to remain silent. Anything you say may be used against you. You do have the right to communicate with counsel, family, and friends, and I can assist you in doing that if you would like. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today?
I'm sorry, Judge. We're actually appointed on
The
this.
underlying?
Yes, we are. And it looks like, I just checked the jail site. Mr. Williams was in jail in Orange County Jail at the time of the failure to appear. I suspect that the public defender assigned just didn't check or didn't know. If anyone wants to double check that, the date that he was booked was 9/21, and he's been in jail ever since. The date on the FTA that the court is considering is on 10/4.
State?
Your Honor, I would trust the findings of defense counsel here.
Retrial?
Yeah, it came in as okay, so it looks like it's a local warrant. It was add-on charges. This case was an add-on charge, so it was a local warrant. That was done on November 5th, because he's here today. But his original, when he was in here, was a possession of cocaine and a possession of drug paraphernalia. He was RO'd on that. So this is an add-on.
Does IMS show you when he was booked, though?
Let me see.
I have 9/17.
One moment. Okay, so one moment.
Oh, no, not the 21st, I'm sorry. 21st, not the 17th.
April, okay, so he was booked in for that 2021 CF 4933, April 29th of this year.
But then this time.
Yes.
He's been in jail since 9/21. Yeah. Yeah, sometimes we just don't.
You should have.
Judge, I'm not doing a great job of explaining this,
So
but
when he came in on September 21st, right, for the possession, he was RO'd on that. But then he was out on bond for the 2021 CF 4933. It was closed out. It was put in as a detainer out on bond. It was closed out. No action per Judge Gibson, but then a local warrant came out for that case. It was an add-on, local warrant, but that case happened back in April 29th of this year. The failure to appear.
I think I'm being more confusing than I have to be. My point, all I'm trying to say is that he was booked in OCJ on 9/21 and has been here ever since. So he couldn't have failed to appear willfully on 10/4 since he's been in Orange County.
Okay, my concern, counsel, is what discretion do I have to change a capias if a capias is set at a bond amount of 0?
It's a warrant like any other warrant, and I think the Norris case that the Osceola public defender cited is the case that gives you the authority to change the bond amount on any warrant, so you could ROR. I can pull the citation if you'd like.
Here's what I'd like you to do, counsel. I'd like for you to file a motion in front of the judge that issued the capias. I'm finding that there is probable cause, and based on what I've reviewed in the capias, I'm setting the bond amount at 0 and finding probable cause, but I am letting you know that you can set this for a motion in front of the judge that issued the capias. I don't believe that I have discretion to change the capias.
Understood.
Okay, good luck to you, sir.
All right. I'll let him know what happened. You're still in jail for now.
The next case is Deshaun Anthony Jones.
Present, Your Honor. Approaching.
Good afternoon, sir. Would you please state your name for the record?
Deshaun Jones.
Mr. Jones, you're here for a first appearance on the charge of trespassing on property after warning. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends, and I can make reasonable accommodations should you wish to do so. You also, sir, have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today?
Yes.
Okay, so at this point, I am going to appoint the Office of the Public Defender to represent you. I have reviewed the arrest affidavit, and I am finding probable cause to support the charge. Let's see. No victim witness. Does the defense wish to be heard on bond?
Your Honor, the state and I discussed this case, so I'll defer.
We discussed this case this morning. The state will decline to prosecute in this case.
Okay, you're going to enter a null pros?
Yes,
Okay.
or no bill.
Okay, the state is choosing not to prosecute this action, sir.
Okay.
You have a nice day. Did you file that null pros, counsel?
Yes, we filed it already.
Okay. One moment, please. Okay, the next case is Nathaniel Patricio Mitchell. Would you state your name for the record, sir?
Daniel Patricio Mitchell.
Good afternoon, Mr. Mitchell. You are here for a first appearance on 3 charges: aggravated battery of a pregnant person, domestic violence. The second charge is battery, domestic violence, and the third charge is false imprisonment. It's also under domestic violence. You have the right to remain silent. Anything that you say here today may be used against you. You also have the right to communicate with counsel, friends, and family. Reasonable accommodations may be made if you wish to do so. You also have the right to an attorney. Would you like me to appoint the office of the public defender to represent you today? There's an assistant public defender next to you, sir. Would you like for me to appoint her to represent you?
No.
Okay, do you have your own attorney, sir?
No.
So you wish to proceed without an attorney?
I guess I'll use the public defender.
Okay. At this time, I will appoint the office of the public defender to represent you. I have found probable cause. After reviewing the affidavit, I see that we have a witness who has come today. Ma'am, would you please raise your right hand and be sworn in?
Do you swear or affirm the testimony about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name for the record and spell your last name.
Madeline Silverio, Silverio.
Good afternoon, ma'am. State you may inquire.
Ma'am, are you concerned that an incident like this could happen again?
No, sir.
Thank you. That's all I have.
Is there anything else you'd like to bring to my attention, ma'am?
Yes, ma'am. If there is a reconsidering, I would like for you to have a no violent contact, because we do have kids and we do live together, and this is like one of the first time we actually had a small argument that went out of control, but I actually I am safe around him, and we've been together for 4 years and we're engaged. And
would you speak up a little, please, ma'am? It's hard to hear you. I know you have a mask on. I know it's difficult.
I'm like kissing the microphone.
I know.
Sorry. Well, I'm sorry. Let me repeat myself. So if anything, I would want you to reconsider a no violent contact. Due to that, we do have kids, a 2-year-old, and he does take care of them. He's the one that takes them to school and does everything. I'm a stay-at-home mom right now. And I'm safe around him. It was just one thing that happened, and I just wish that the court would actually have his side on anything that he requests.
Defense, did you want to inquire?
No, Your Honor.
And Your Honor, we did qualify Mr. Mitchell for straight pretrial release. He has no priors.
Okay, so at this point, is it not a VOP then? I think I'm reading it wrong.
No, Your Honor.
Okay.
No.
Okay, thank you. All right, at this point, I will find pretrial release. However, I am going to set the bond amount on count 1 at $5,000, on count 2 at $1,000, and on count 3, let's see, at $1,000. In addition, I understand what she has told me today, and I thank you for appearing today and letting the court know that. But based on what I have reviewed, I am going to order that there is no contact until another judge can review this and hear something further. The reasons are those that I have read as set forth in this affidavit. I imagine that you all live together. Is that correct, sir? Okay, so at this time, what I will allow you to do is to return to the residence to gather your belongings. And you should be accompanied by law enforcement when you do that. In addition, when you go to schedule that, do not schedule that with her, okay? It has to be scheduled through other people, and you have to be accompanied by law enforcement. You are to consume no illegal substances, and you may not have a firearm. Otherwise, you all are welcome to bring any further issues to the attention of the next judge. Have a nice day, sir.
Thank you, Your Honor.
Thank you for coming. The next case is James Scott Ottman.
Present, Your Honor.
Mr. Ottman, will you state your name, please, for the record?
James Scott Ottman.
Mr. Ottman, you are here for a first appearance today on battery, the charge of battery, and also the charge of obstructing justice and tampering with a misdemeanor proceeding. You have the right to remain silent. Anything you say may be used against you. You also have the right to talk to counsel and family and friends, and accommodations can be made to assist you in doing so. You have the right to an attorney. Would you like me to appoint the office of the public defender to represent you today?
Yes, ma'am.
Okay, at this point, I will appoint the office of the public defender. I am also finding probable cause in this case. Ma'am, thank you for coming today. Would you raise your right hand to be heard?
Do you swear or affirm that testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record and spell your last name.
Amanda King, King.
State you may inquire.
Ma'am, are you concerned that an incident like this could happen again?
Yes.
No further questions, Your Honor.
Defense?
Can I have a moment, Your Honor?
Yes.
I have no questions, Your Honor. Just
Thank-
argument for conditions.
Okay, anything you'd like to bring to my attention, ma'am?
Yes, ma'am. This was not the first incident. This was just the first time I called the police about it. He's threatened several times to put me in a body bag, and been to prison, not afraid to go back to prison. That's why I've been afraid to speak out until now. And I do fear for my safety.
Okay, thank you, ma'am. State you wish to be heard on bond.
No, Your Honor.
I'm sorry, defense, would you like to be heard on bond?
Yes, Your Honor. I do see, based on the paperwork, that Mr. Ottman qualifies for pretrial release. He does have an alternate address where he can reside, so defense has no objection to a no contact order. Additionally, it looks like, oh, never mind, strike that. That's all, Your Honor.
So do they reside together?
At this point, yes, but he has a secondary address that he can reside at. So we would just be asking for a one-time return with law enforcement.
Pretrial release?
Yes, Your Honor, we did qualify Mr. Ottman for pretrial release, and alternate address was verified by our department.
Okay. At this point, I am going to put you on pretrial release with a bond of $5,000. I am also going to order, sir, that you have absolutely no contact with the alleged victim, with her. Do you understand that, sir?
Yes, ma'am.
Do you understand that that contact includes just verbally, physically, social media, no contact whatsoever? You understand, sir?
Yes, ma'am. Can I ask a question?
Yes, sir.
We have an 8-year-old daughter. Do I have to go through DCF to I don't know how to go about seeing my daughter, but I know I can't talk to her and I don't want to. But I don't know the proper chain of command.
So for now, you're going to need to communicate with your attorney and DCF about that. You cannot coordinate visitation with the alleged victim. In addition, I will allow you a one-time return to the residence to gather your belongings, but you have to be accompanied by law enforcement when you do that, and you cannot schedule that return with her. Do you understand that, sir?
Yes, ma'am. Can I also ask a question on that?
Yes.
I asked that for law enforcement when I was there. I own a construction company. I do handyman stuff and all my tools are there. Does my one-time thing count those tools?
If those are your belongings, sir, you have the right to go back and gather your belongings with the accompaniment of law enforcement.
Yes, ma'am. That the law enforcement told me that.
Yes. In addition, sir, you are to consume no illegal substances, you are to consume no alcohol, and you are to have no firearms. Have a nice day, sir.
Thank you, ma'am.
You're on his.
Oh, 2 counts.
Yes.
I'm sorry. Okay, on count 2, the bond is going to be set at $500. Have a nice day, sir.
Your Honor,
Yes.
Your Honor,
Yes.
I'm sorry, but he has my car key to my car on his keys when he was arrested, and I would like to request that key back, please.
Counsel, any objection to the return of the key?
No, she can have it.
I
I don't know how to get it.
I don't, well, that's, I think logistically, hold on.
I know when it comes to property, he does have 10 keys in his property. Usually what happen is property will give a form to Mr. Ottman, giving him permission
Whoops.
to give Mr. Ottman the keys. I believe that's how they do it, Your Honor. But he's got to give the permission.
Okay.
Otherwise, you say different on the court order.
Right.
Okay.
Okay, so we'll see if they will give property permission to give you the keys back, and if not, you all can facilitate that exchange through law enforcement. Yes, sir.
Ma'am, I don't have a problem with giving her key. If property will let me do that, she can have it first most. The problem is that I know that when I took my keys, law enforcement also told me that it was smart for me to have my own truck keys.
If those are your keys, sir, that's different. If it sounds, ma'am, like you have.
I have a key on my ring from Miss Amanda that is for her car.
Okay, and so property has permission to return that to her if she goes and asks, correct?
Yes, ma'am, that FJ Cruiser key. Yes, ma'am.
Okay, so you can have your key back, ma'am. You've been given permission. Have a nice day and thank you for coming.
Thank you, ma'am.
The next case is Alan Valalan. Will you please state your name for the record, sir?
Alex Villalon.
Okay. Mr. Villalon, you are here for your first appearance on the charge of battery. It's a domestic battery by strangulation. You have the right to remain silent. Anything you say may be used against you. You have the right to communicate with counsel, family, and friends, and accommodations may be made to assist you in doing so. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today? Okay, so I will go ahead and appoint the Office of the Public Defender. I am also making a probable cause finding in this case based on what I have reviewed. I see no victim witness. Would the defense like to be heard?
Yes, Your Honor. Mr. Villalon, I'm sorry, has no criminal history. He does qualify for pretrial release. So we would ask that he be released on pretrial release without having to post monetary bond.
Pretrial release?
Correct, Your Honor. We did qualify Mr. Villalon for pretrial release.
State?
I mean, Your Honor, we would object. It's a dangerous crime under the statute. We would recommend a bond at minimum $5,000.
Okay, at this point, I am going to award pretrial release. In addition, I'm going to set bond at $5,000. Let's see, he does reside with the alleged victims, correct?
It appears that way from the affidavit, Your Honor, but Ms. Robin will correct me if I'm wrong. I think they
yes.
verified a separate.
Yes, Sharon, and what will happen is, once he has a pretrial release, he'll have to find an alternate address to reside at. He'll be given all those conditions once he gets released.
Okay, thank you. And so, sir, you're to have no contact with the alleged victims in this case. If you do need to return, you are going to have conditions of your pretrial release. But if you do need to return to your residence, you should do that only with the accompaniment of law enforcement. I will allow you to return one time to gather your personal belongings. Otherwise, you are to have no illegal substances, no firearms, and no contact. And the other conditions will be set forth in accordance with the pretrial release. Have a nice day, sir.
You're all set.
The next case is Cheyenne Elizabeth Armand. Ma'am, will you please state your name for the record?
Cheyenne Elizabeth Armand.
Ms. Armand, you are here for a first appearance in the charge of battery. You have the right to remain silent. Anything you say may be used against you. You have the right to communicate with counsel, family, and friends, and accommodations may be made to assist you in doing so. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today? Okay, so at this point, I will appoint the Office of the Public Defender. In addition, I am finding that there is probable cause in this action. Pretrial release, would you like to be heard?
Your Honor, we did qualify Ms. Armin for pretrial release. She has no prior history.
Okay, thank you, and I apologize. I did not see you, ma'am. Would you please raise your right hand to be sworn?
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record, spell your last name.
Alexandra Armand, that's Armand.
State, you may inquire.
Ma'am, is this the first time an incident like this has occurred?
Yes.
Are you concerned that it could happen again?
No.
Okay, thank you.
Defense, would you like to inquire?
Yes, Your Honor. Ma'am, do you wish to have contact with your sister going forward?
Yes, I do. May I add that we do live together in the same household with our mother, and we both have nowhere else to go, so it would be extremely difficult to have no contact as well. But I do not wish to have no contact.
Okay. But outside of it being difficult for her, you still want to have contact?
Yes, I still do want to have contact.
Okay, and you want to keep living together?
Correct.
Okay, thank you.
Are you afraid of her at all, ma'am?
No, I'm not, Your Honor.
Okay, at this time, I am going to find that she qualifies for pretrial release and set bond in the amount of $500. Ma'am, you are to consume no illegal substances. Do you understand? Okay, have a nice day, ma'am.
No hostile.
Oh, no hostile contact as well with the alleged victim. So you're having contact with her because she's asked me for this, and I think that it's reasonable given what I have seen and heard. But you may have no hostile contact with her. Do you understand? Okay, have a nice day, ma'am. Thank you, Madam Clerk.
Thank you, Your Honor.
The next case, thank you for coming, ma'am, is Jadis Francis Cunningham. Would you please state your name for the record?
Jadis Cunningham.
Ms. Cunningham, you are here for your initial appearance in the crime of battery, the charge of battery. You have the right to remain silent. Anything you say may be used against you. You also have the right to communicate with counsel, family, and friends, and reasonable accommodations may be made if you wish to do so. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today? Okay, so at this point, I will appoint the Office of the Public Defender, and I am finding that there is probable cause in this case. Would pretrial release like to be heard?
No, Your Honor.
Defense?
Your Honor, Ms. Cunningham has no criminal history. I see no prior arrests. So at this point, we would just ask for a reasonable bond.
Yeah, we didn't qualify Ms. Cunningham, Your Honor. One, she's unstably housed. She has no emergency contact. So we weren't able to verify any kind of residential and community ties.
Okay. Okay, at this point, then I am going to set bond at $1,000. In addition, ma'am, you are to have no contact with the alleged victim. Do you understand what no contact means, ma'am? Yes. In addition, you are to have no firearms and consume no illegal substances. Have a nice day, ma'am. The next case is Rodney Hayward. Would you please state your name for the record, sir?
Rodney Hayward Jr.
Okay, Mr. Hayward, you are here for a first appearance on the charge of battery of domestic violence. You have the right to remain silent. Anything you say today may be used against you. You also have the right to communicate with counsel, friends, and family. And in the event you wish to do so, reasonable accommodations will be made. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today?
No.
Do you have a private attorney, sir?
No.
So do you wish to proceed today without any lawyer?
Yes.
Okay. Let's see. As I stated before, I am finding that there is probable cause in this case. Pretrial release, anything to bring to my attention?
Your Honor, we did qualify Mr. Hayward for pretrial release. His last conviction was back in 2015 for a driving while license suspended. He has no prior batteries. He does have some out-of-state convictions back in juvenile for conspiracy, manufacturing, and delivering of CDS.
Are those all while juvenile?
Yes, ma'am. Except for the duelist. That's current. That's an adult.
State, would you like to be heard?
No, Your Honor.
Okay, at this point, sir, I am going to find that you qualify, or excuse me, I am going to put you on pretrial release, which will have its own conditions. In addition, I'm going to set bond at $500. You are to follow the conditions of the pretrial release, and in particular, you are to have no contact with the alleged victim. Do you understand what no contact means, sir?
Yes. But,
Yes, sir.
she is not, pressing the charges. And she didn't.
Probably not a great idea to be talking right now.
Sir, just please remember that anything you say may be used against you. In addition, if she has something that she would like to bring to someone's attention, to the state's attention or another judge's attention, she will have an opportunity to do that. At this point, based on what I have reviewed in the affidavit, I am finding that there's probable cause for the charge. That's, let's see. And so for that reason, I put you on the pretrial release with the $500 bond, but you are to have no contact with her, okay? And in the event that she needs to reach out to someone, she may do that. Do you reside with her?
Yes.
Okay, so what I am going to do is I'm going to permit you a one-time return to the residence so that you can gather your personal belongings. But you cannot schedule that with her. And you have to be accompanied by law enforcement when you go and pick up your belongings. Do you understand that, sir?
Yes.
Okay. And in addition, sir, you are to have no firearms and to consume no illegal substances.
Okay.
Have a nice day, sir.
Thank you.
The next case is Zana Kai Noel Reed.
Present, Your Honor.
Will you state your name for the record, please, ma'am?
Zana Kai Noel Reed.
Ms. Reed, you are here for a first appearance for the charge of battery. You have the right to remain silent. Anything you say may be used against you. You also have the right to communicate with counsel, family, and friends, and I can assist with reasonable accommodations in the event you would like to do so. Also, you have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today? There is an assistant public defender standing next to you. Okay, at this point, I will appoint the Office of the Public Defender to represent you. In addition, I am finding that there is probable cause in this case.
Your Honor, there's a victim.
Oh, thank you.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record.
Jordan Austin.
You can put your hand down, Mr. Austin. State you may inquire.
Mr. Austin, is this the first time an incident like this has occurred?
Yes.
Are you concerned that an incident like this could happen in the future?
No, not at all.
Are you in any way afraid of harm from the defendant?
No, at all. Like, this is my girlfriend. I love her. Like, I'm no way in shape or form feel fearful.
Okay, thank you. No further questions, Your Honor.
Defense?
Mr. Austin, would you like to have contact going forward?
Yes, I would.
Thank you.
Would pretrial release like to be heard? I mean,
Yeah, Sean, we did qualify Ms. Reed for pretrial release.
okay, ma'am, at this point, I am going to put you on pretrial release, so those conditions will be made known to you. And in addition, I think I'm just going to set it at pretrial release today.
Judge, can I
Yes.
say
Yes.
something? Yeah, so when the officer came to the apartment, he never fully understood everything that happened. He kind of used his own judgment to say that she was the aggressor. But in actuality, what happened was that emotions were high. And I was actually out on the balcony, and she actually was just trying to grab me to kind of pull me inside. And so when the officer showed up, when he saw the marks on me, he assumed that the marks were as her being aggressor, when it wasn't the case at all. So when I heard the charge being battery, it's a false charge because, again, she was just doing everything she can to protect me. There was nothing that happened yesterday that states that this should be a battery charge.
Okay, thank you for bringing that to my attention. At this point, I have a very limited role. Based on my review of the affidavit, I am finding probable cause to support the charge that is listed. But you will have an opportunity. You can speak to the state or at future hearings about this as well. But for today, I'm going to put her on pretrial release. In addition, ma'am, I am allowing, based on what I have heard, for you to have contact with him. You may have no hostile contact. Do you understand that, ma'am? Yes. Okay. All right. Thank you, ma'am. Have a nice day. Please state your name for the record, sir.
Sheila Villain.
Mr. Shilov, you are here for a first appearance for the charge of battery. You have the right to remain silent. Anything you say may be used against you. You also have the right to communicate with counsel, friends, and family, and reasonable accommodations can be made if you would like to do so. You also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you? Okay, so at this point, I am going to appoint the Office of the Public Defender. In addition, I have reviewed everything and found probable cause. Let's see, we don't have any victim state. Did you want to say anything?
No, Your Honor.
Okay, pretrial release.
Your Honor, we didn't qualify Mr. Sheila, even though he doesn't have any priors. He's unstably housed. We have no kind of community ties, no emergency contacts to verify any residential information.
Okay. Sir, do you live with the victim? Okay. Defense, would you like to be heard on bond?
We just asked for a minimal bond, Your Honor, because of his no prior history.
And it is no prior history on your end for pretrial release. Okay. Okay, thank you. At this point, after having found probable cause, I am going to enter a bond amount of $2,000, and I'm further ordering you, sir, to have no contact with the victim. Do you understand what no contact at all means, sir? Okay. You do not live with the victim. You are to have no firearms, sir, and you are to consume no illegal substances. Have a nice day, sir. One moment, please. Okay, we're going to hear this case and then we'll take a 10-minute recess, okay? Ma'am, would you please state your name for the record? Ms. Bellinger, you are here for a first appearance on the charge of grand theft in the third degree, greater than $750 and less than $5,000. You are also charged with theft by an employee. You are here, you have the right to remain silent. Anything you say may be used against you. You also have the right to communicate with counsel, family, and friends, and reasonable accommodations can be made if you would like to do so. You also have the right to an attorney, ma'am. At this point, would you like me to appoint the Office of the Public Defender to represent you? Okay, thank you. At this point, I will appoint the Office of the Public Defender. In addition, after having reviewed the affidavit, I am finding probable cause. Let's see, there's no pretrial release. Did you want to be heard on anything?
Your Honor, yeah, we didn't qualify Miss Bellinger. One, she just moved here. She just transferred here from South Florida. She's unstably housed, no emergency contact, and we weren't able to verify any kind of community ties. Her last offense was back in June of 2019 for a misdemeanor petty theft.
Defense, would you like to be heard?
May I just have a quick moment? Your
Sure.
Okay, all right. Your Honor, we would just ask for minimal bond based on the lack of history. Although I do think there's technically probable cause for both offenses, I think they're duplicative. So based on that, I would ask for 1,000 and 100. Ms. Bellinger does have an address she can give the court as to where she can reside in Orlando.
Anything from the state?
No position, Your Honor.
Okay, thank you. At this point, I am going to set bond on count one, the grand theft of $1,000 for theft by employee of $150. In addition, ma'am, you are not to have contact with the victim, who I believe would be the owner of that store. You also may not return to that store. Do you understand? In addition, you are to have no firearms and you may not consume any illegal substances. Do you understand? Have a nice day, ma'am. Okay, then we will be in recess. I have that it's 2:51. We'll come back at 3 o'clock.
Yeah.
Okay, we are back on the, Sir, would you please state your name for the record?
Matthew Carter.
Okay. One moment, please. Mr. Carter, you are here for your first appearance on 3 charges: resisting an officer with violence, battery on an officer, and resisting an officer as the 3rd charge. Let's see. You have the right to remain silent. Anything that you say today may be used against you. You also have the right to speak with counsel, family, and friends, and reasonable accommodations can be made in order for you to do so. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today? Okay, at this point, I am going to appoint the Office of the Public Defender to represent you. I have reviewed the charging affidavit and I am finding that there is probable cause in this case. Would the defense like to bring anything to my attention?
Judge, just that he has almost no criminal history. The only prior criminal history is a 2009 trespass. If it's possible, I'd like the court to consider the mental health diversion release program. Based on the newest administrative order, I believe he would qualify.
Pretrial release, have any comment?
Yeah, Your Honor, we weren't able to interview Mr. Carter. He was held back in Safe Book for a while, so we weren't able to, get any information from him. It may be a possibility. I have no idea as far as the mental health. The only history he does have is a trespass. He does have some Florida arrest history, but they were not convictions: aggravated assault with a weapon, battery, violation of pretrial release, domestic violence, and a trespassing charge.
Would the state like to be heard?
No, Your Honor.
Okay, at this time, I'm going to allow you to file any motion for that mental health diversion before the next judge. I am going to set bond in this case on count one at $2,500, Count 2, the battery at $3,500, and for resisting an officer at $500. In addition, sir, you are to consume no illegal substances and to have no firearms. Do you understand that? Have a nice day, sir. Okay, the next case is going to be Shayla Davis.
Present.
Would you please state your name for the record?
Shayla Davis.
Ms. Davis, you are here for a first appearance on the charge of aggravated battery on a pregnant person. You have the right to remain silent. Anything you say may be used against you. You also have the right to communicate with counsel, family, and friends. Reasonable accommodations can be made in the event you would like to do so. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today? Okay, at this time, I will appoint the Office of the Public Defender. I have reviewed the arrest affidavit, and I am making a finding of probable cause. I don't see anyone waiting to be heard on this. But does pretrial release want to be heard?
Yes, Your Honor, we did not qualify Ms. Davis for pretrial release. She has an active warrant out of Georgia for disorderly conduct, but there's limited extradition. So they're not going to extradite her.
Okay. Does the state need to be heard?
No, nothing from the state, Your Honor. We'd leave it to the discretion of the court.
Would the defense like to be heard?
Your Honor, I would just note her lack of criminal history and ask for a reasonable monetary bond.
Is there no criminal history other than the charge in Georgia?
Your Honor, she does have out-of-state, well, she has no out-of-state conviction, but she does have out-of-state arrest.
Okay.
But then she has that active warrant out of Georgia.
Okay, and limited extradition, so they're not going to come. Okay. All right, at this time, based on my finding of probable cause, I am going to set a bond amount in the amount of $3,500. In addition, ma'am, you are to have no contact at all with the alleged victim. That includes telephonic, social media, all contact. Do you understand that, ma'am? Okay, in addition, ma'am, you're not to consume any illegal substances and you are to have no firearms until you hear something further. Do you understand, ma'am? Yes. Have a nice day. All right, Teso Ron Favors.
Yes.
Will you please state your name for the record, sir?
So Ron Favors.
Okay, Mr. Favors, you are here for a first appearance for the charges of distribution of cocaine. There are 2 counts of distribution of cocaine, and then the third count is for possession of cocaine. You do have the right to remain silent, and anything you say today may be used against you. You also have the right to communicate with counsel, family, and friends. Should you wish to do so, reasonable accommodations may be made. Would you like for me to appoint the Office of the Public Defender to represent you, sir?
No, thank you.
No? Do you have your own attorney in this case, sir?
I plan to.
You plan to. I can appoint the Office of the Public Defender just for purposes of today if you would like.
No, thank you.
Okay, so you wish to represent yourself?
Yes.
Okay, all right. At this point, I am finding probable cause. Pretrial release, anything? Okay, state anything?
Nothing from the state, Your Honor.
Okay, is there anything you would like for me to consider when setting your bond?
No.
Okay, at this point, as to count 1, I'm going to set bond at $5,000. As to count 2, $2,500. As to count 3, $150. Sir, as conditions of your bond, you are not to have any firearms. Do you understand?
Yes, ma'am.
And in addition, you are to consume no illegal substances. Do you understand?
Yes, ma'am.
Have a nice day, sir. Ma'am, would you please state your name for the record? Ms. Harnish, you are here today for a first appearance on, looks like 3 charges. 3 charges of failure to appear. Okay, you have the right to remain silent today. Anything you say may be held against you. You also have the right to speak with your attorney, with your family and your friends, and reasonable accommodations can be made to help you do so. You also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you today? She is an assistant public defender.
I mean, I'm guilty, but
Ma'am, anything that you say today may be used against you. At this point in time, I will appoint the Office of the Public Defender. to represent you. In addition, based on my review of the arrest affidavit, I am finding probable cause. Anything that anyone needs to bring to my attention?
No, Your Honor.
No, Your Honor.
No, Judge.
Okay, at this point, I am going to set a bond amount on count 1 for failure to appear of $150. On count 2, it will be $100, and on count 3, $5,000. Let's see. Right? Okay, one moment, please. Well. Okay, I apologize. Okay, I need to clarify something. It was written incorrectly on my sheet. So as to count 1, for the battery on the law enforcement officer, and then for failure to appear, it's $5,000. As to count 2, $150, and as to count 3, $100. In addition, ma'am, you are not to consume any illegal substances. Do you understand that?
Yes, ma'am.
Yes? Okay, have a nice day, ma'am.
I'll let him know. Okay. What's up?
Sir, will you please state your name for the record? Mr. Howard, you are here for your first appearance on the charge of possession of material depicting sexual performance by a child greater than age 10. You have the right to remain silent. Anything you say today may be used against you. You also have the right to communicate with counsel, family, and friends. Reasonable accommodations can be made if you would like to do so. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you at this time? Okay, at this time, I will appoint the Office of the Public Defender. The Assistant Public Defender is next to you. In addition, I have reviewed the arrest affidavit, and I am making a finding of probable cause. Would pretrial release like to be heard on any conditions?
No, Your Honor.
State?
Not at this time, Your Honor.
Defense, is there anything that you'd like for me or to bring to my attention before I set bond?
No, Your Honor.
Okay, at this point, having found probable cause, I am going to set bond in the amount of $1,000. Sir, you are also not to consume any illegal substances, or not to possess or consume. You may have no illegal substances. Do you understand that?
Yes, ma'am.
Okay, there was no actual contact, correct? Everyone I don't need is contact of concern? I don't believe so. Okay.
No, I don't see.
It's just of the material, correct?
Material, yes, Your Honor.
Okay, your bond is set in the amount of $1,000. Have a nice day, sir.
Your Honor, he has
Yes.
additional, he has a 2020 CF 6233AO. It's an add-on charge.
An add-on
Wait,
charge?
you
I don't
know
think
what,
I.
Your Honor, give me one moment. Let me just. Oh, yeah, okay, he was already seen on them. I'm sorry. I'm just looking to check. Okay. He's okay. He's all set. I'm sorry. He was already heard on those cases. I just wanted to double check. Thank you.
Okay, thank you.
Yeah, they can mail it.
Will you please state your name for the record?
Stacia Lee.
Miss Lee, you are here for a first appearance on 4 charges: armed burglary of a dwelling with a firearm, grand theft of the 3rd degree with a firearm, grand theft in the 1st degree, and possession of a firearm in the commission of a felony. You have the right to remain silent. Anything you say today may be used against you. You also have the right to speak with your attorney, friends, and family, and reasonable accommodations can be made to help you do that. You also have the right to counsel. Would you like for me to appoint the Office of the Public Defender to represent you today?
Yes.
Okay, at this point in time, I will appoint the Office of the Public Defender to represent you. In addition, based on the arrest affidavit that I have reviewed, I am finding probable cause in this case. State, do you, are any of these punishable by life?
Yes, Your Honor, I believe the armed burglary of a dwelling with a firearm is.
What's the state asking for on this?
The state is asking for no bond in this case, Your Honor.
One moment, please. I'm looking it up. Would pretrial release like to be heard?
No, Your Honor.
Defense?
Judge, I can't challenge PC because this was a warrant. So that's done and over with. But as far as a bond, I would ask that the court set one. Based on my review of the warrant affidavit, it doesn't appear that any video shows Miss Lee doing anything specific with respect to burglary. There's no indication to me that she had a firearm or that she armed herself with a firearm. Obviously, the warrant that was signed by a judge puts her there and establishes probable cause, but for purposes of bond, I think that this court can infer that she may not have been a full participant in exactly what she's charged with. So I'd ask that a reasonable bond be set.
And the burglary was, according to the affidavit, let's see here. State, do you have any response to that?
Your Honor, what I'm attempting to do is look at that affidavit. I mean, I don't have any case law that would go directly against what defense counsel is proposing. But I would stand by our initial position of no bond.
And that's based on the PBL for count 1, armed burglary of a dwelling?
Yes, Your Honor.
Defense, is it your position as well that that is a PBL?
It is, Judge.
Okay. All right, and I appreciate your candor. Anything from pretrial release? I can't recall if I already asked
Your
you.
Honor, she has no priors.
Okay, at this point, I am going to order no bond on count 1. It's an offense that's punishable by life. As to count 2, grand theft in the 3rd degree, the bond is set at $150. As to count 3, grand theft in the 1st degree, bond is set at $150. For possession of a firearm, one moment. For possession of a firearm during the commission of a felony, I am going to set bond at $1,000. It's no bond as to count 1. In addition, you are to have no contact with any of the alleged victims in this case. You are not to return to any scene. You are to have no firearms, and if you do have a firearm, you need to surrender that to law enforcement, and you are to have no illegal substances. Do you understand?
Yes.
Have a nice day, ma'am.
Judge, can I briefly just ask a clarifying question?
Yes.
For the record? So is the court relying on the Thwartman case with respect to not needing to make a finding of proof evident presumption great, or are you making a finding of?
My understanding is that the probable cause that I've reviewed in this case is sufficient and that she can have, it's the Arthur hearing that you're referring to, correct? And that the Arthur hearing can be heard at a later date.
Okay.
And I believe that there's an inter-district split, but I'm probably not as up to date as you all are. So you're always welcome to make arguments to me, counsel. But based on what I'm finding in that probable cause and what I've reviewed, I think that the allegations are sufficient. And then the trial division can either set a bond or can do the Arthur hearing and determine whether bond is appropriate.
Thank you.
But, I'm sorry?
Firearms?
Immediately.
And Judge, I looked it up over the
Yes,
break.
thank you.
Once you said that, and actually, the Florida Supreme Court granted cert and held oral argument on it. We just don't have an opinion yet. So there is exactly a conflict, and so nobody knows what.
Okay, well, I'll be back on Thursday. Maybe we'll know.
Yeah.
Thank you for that, counsel. I appreciate you researching it. Sir, would you please state your name?
Kenton Lester.
Okay. Mr. Lester, you are here for your first appearance for the charge of trafficking in cocaine greater than 400 grams. You have the right to remain silent. Anything that you say today may be used against you. You also have the right to speak with counsel, family, and friends. Reasonable accommodations can be made to permit you to do that. You also have the right to an attorney. Would you like me to appoint the office of the public defender to represent you at this time?
At the moment, yes, ma'am.
Okay, so I will go ahead and appoint the office of the public defender to represent you. Based on what I have reviewed on the arrest affidavit, I am finding probable cause. Anything that pretrial release would like to bring to my attention? Nope. State?
Nothing, Your Honor.
Defense?
Your Honor, we're asking for a bond reduction. Mr. Lester's informed me that he has a child to care for and would be willing to put up collateral. However, the collateral that he has at this time would not amount to being able to afford a bond of this amount. So we'd ask for a reduction based on those arguments.
Okay, one moment, please. Okay, at this time, I am going to after my finding of probable cause, I am going to set bond in the amount of $250,000. In addition, you are to have no illegal substances, sir, and you are to have no firearms. Do you understand?
Of course, ma'am. Yes.
Okay, have a nice day, sir. Good afternoon, sir. Please state your name.
Gil Lopez.
Mr. Lopez, you are here for a first appearance on the charge of possession of methamphetamine. You have the right to remain silent. Anything you say may be used against you. You also have the right to communicate with counsel, family, and friends, and reasonable accommodations can be made in the event that you would like to do so. You also have the right to an attorney. Would you like for me to appoint the office of the public defender to represent you today? Okay, at this point, I'm going to appoint the office of the public defender to represent you. In addition, I have reviewed the arrest affidavit, and I am finding that there is probable cause in this case. Pretrial release, would you?
Yes, Your Honor, we did qualify Mr. Lopez for pretrial release.
Any priors?
Yes, he does have, his last conviction was back in 2004 for a grand theft of a motor vehicle. He does have some Florida arrests, but he only has one felony, one misdemeanor, no failure to appears. He has no out-of-state history.
Any response from the state?
Nothing from the state, Your Honor.
Anything from the defense?
No, Your Honor, we would just be requesting straight PTR or $1,000 bond.
Okay, at this point, I am going to set PTR and a $500 bond. So there will be conditions that are imposed pursuant to that pretrial release, sir. Make sure that you appear at every upcoming court appearance. Do you understand? Yes, ma'am. Have a nice day, sir.
Thank you.
Oh. In addition, sir, you are to have no illegal substances and no firearms. Do you understand? Yeah. Have a nice day.
You have to pay that and second trial release. Well, or 10%. So you, so
Just wait for the attorney. Sir, will you please state your name for the record?
Ismael Quiñones Carmona.
Mr. Quinones Carmona, and I apologize if I'm mispronouncing that, sir, but you are here for a first appearance on the charge of aggravated stalking after an injunction. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends, and reasonable accommodations can be made if you would like to do that. You also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you? At this point, I'm going to appoint the Office of the Public Defender to represent you today. Based on my review of the arrest affidavit, I am finding probable cause. Let's see, and this is after an injunction. Pretrial release, anything?
No, Your Honor.
State?
Nothing from the state, Your Honor.
Okay, one moment, please.
Oh, yeah.
Okay, so defense, anything that you would like for me to consider?
No, Your Honor, thank you.
Is there, so an injunction was in place and there was a violation of that injunction that's alleged? Is that correct, defense?
It appears that way, Your Honor. It appears to me that it's a civil injunction originally,
Okay.
and then the violation is the crime now.
Okay, and state you have no input on this?
One moment. Maybe I could confer with defense here.
So, am I? For the original injunction.
So that's what I'm trying to do. This is Orange County.
I thought so.
Yeah. Okay, yeah, okay.
Well, it depends.
Your Honor, could you restate the questions that I'm sure,
That's okay. Defense, did you want to bring anything to my attention before I set the bond amount?
No, Judge.
Okay, we were just waiting on, okay.
Oh, I'm sorry, I didn't know you were waiting on me.
I thought you all were conferring and then you
well,
would.
what I wanted to, I think what I wanted to be sure about was that everything was filed together. The burglary, the aggravated stalking after the injunction, and the two subsequent violation of domestic injunctions. And they are all filed together.
Okay, thank you. At this point, given that it's a violation of an injunction, there's already an injunction in place, and there is probable cause. I am going to set the bond amount for that reason in the amount of $20,000 on the one count of aggravated stalking after an injunction. I'm concerned in particular about the ability to follow the rules set by the court. In addition, sir, you are to have no contact with the victim. That's no contact at all, not through a phone, text messages, social media, certainly no face-to-face contact. That includes hostile contact, but is also regular old contact. Do you understand that, sir?
Your Honor.
Okay. You don't live with the alleged victim, correct? Okay. In addition, sir, you may have no firearms, and you may have no illegal substances. If you do happen to have firearms, you need to surrender those to law enforcement for the time being. Do you understand? Have a nice day, sir.
Okay, so you're good.
Sir, will you please state your name for the record?
Cedric Taylor.
Mr. Taylor, you are here for a first appearance on 3 charges: distribution of cocaine. The second charge is also for distribution of cocaine, and the third charge is for possession of cocaine. I'll wait for the Assistant Public Defender.
I'm sorry, Your Honor.
That's okay.
Sorry, Your Honor.
You have, I'm sorry, I could not remember where I was, sir. You have the right to remain silent today. Anything that you say may be used against you. You also have the right to speak with your attorney, with friends, and with family, and reasonable accommodations can be made to let you do that. In addition, you have the right to counsel. Would you like me to appoint counsel today? Okay, so at this point, I will appoint the Office of the Public Defender to represent you, sir. In addition, I am finding probable cause to support the charges set forth in the affidavit. Let's see, anything from pretrial release?
Oh, Your Honor.
State? Nothing from the state, Your Honor.
Defense?
Not at this point, Your Honor.
Okay, at this point, as to count 1, I am going to set bond in the amount of $5,000. As to count 2, the bond amount will be $2,500. And as to count 3, the bond amount will be $150. In addition, sir, you are to have no illegal substances as a condition of bond. Do you understand, sir? In addition, I'm sorry? Oh. In addition, you are to have no firearms. Do you understand, sir? Okay, and then there's a second case Madam Clerk brought to my attention. Let's see, am I looking at the same one here? 1-3. Okay, so that was case number 2021 CF 13807, correct? And then the next is 2021 CF 13809. Is everyone with me on that?
Yes, Your Honor.
Okay. Those charges that you're here for a first appearance for are distribution of cocaine. The second one is also distribution of cocaine. And the third is possession of cocaine. The Office of the Public Defender represents you on that as well. One moment, please. Let's see if these are. Okay, so the 2 different offenses. So this one is on September 16th. Just looking it over.
The other one's the 10th.
Correct. Okay, anything from the defense?
Judge, I would just ask for subsidiary bonds in the amount of $150 on counts 2 and 3, just based on the fact that this is all really one transaction here and it's charged multiple different ways.
State?
Your Honor, I would leave it to the discretion of the court.
Anything from pretrial release? Okay. And there's the administrative order that allows me to do the subsidiaries, correct?
Yeah,
I believe that
yes, Your
that's
Honor.
correct. Okay. All right, I'll go ahead and grant that request. But so that is as to 2 and 3 only, is that? What?
Yes, so it would be the primary, I think, whatever the court puts for the primary, and then would be count 1, and then counts 2 and 3 would be 150.
Okay, so we'll do that. So count 1 will be set at 5,000. Count 2 will be at 150, as well as count 3. It's going to be the same conditions, sir. So you may not have any firearms, you may not have any illegal substances. Do you understand that, sir? All right, so you have a nice day.
And Your Honor, is
Yes.
that, I'm sorry, is that with respect to 807 and 809?
Yes, I think I already ordered that on 807.
Okay.
Yes.
Perfect. Add that up. Mm-hmm.
Next case, please.
Go ahead, Theodore.
Would you please state your name for the record?
Marvin Theodore, Your Honor.
Mr. Theodore, you are here for a first appearance on the charge of aggravated child abuse. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends, and accommodations may be made to assist you in doing so. I don't know if that's mine. Honestly, I have the emergency phone. One moment, please. It's the emergency phone. Good afternoon, this is Judge Brownlee. I'm well, thank you. How are you? Okay, thank you. I'm just in the middle of initial appearances. Okay, I will pull it up in just a moment. Thank you for letting me know. Bye-bye. Okay, so after this defendant, I'm just going to take a look at a warrant. Thank you for everyone's patience. So as I was stating, sir, you have the right to remain silent. You have the right to communicate with counsel, family, and friends. You also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you at this time?
Yes, Your Honor.
Okay, I will at this time appoint the Office of the Public Defender. In addition, I have reviewed the arrest affidavit and I am finding probable cause. I see that there is a woman here to make a statement. Would you raise your right hand, please?
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record and spell your last name.
Shayna Adams.
Thank you, Ms. Evans. State you may inquire.
Ms. Adams, is this the first time an event like this has occurred?
Yes.
Yes. Do you expect that it could happen again?
No.
Thank you.
Ma'am, is there anything you'd like to bring to my attention that was not already asked of you?
Yes. Unfortunately, we're here because we're dealing with a hormonal teenager who doesn't want to listen to any authority. And this is why we're led to be here right now. Unfortunately, my daughter, I call them behaviors. She had a behavior and she was the aggressor in the situation, but because he's the parent and he's the adult, he's being penalized. Now, unfortunately, and hopefully me saying this isn't going against him, but unfortunately, my daughter hit the victim. I call him the victim because he's here because of her. She hit him repeatedly, and then until he got aggravated and hit her back. Not agreeable, but again, I don't feel we should be here. And on my part, if I can ask, I would say, or actually ask for a non-hostile release.
Thank you, ma'am. Defense, anything you'd like to bring to my attention?
Your Honor, it appears Mr. Theodore has no criminal history, no prior arrests. So based on the testimony from the witness, we'd be asking for a reasonable bond to be set and to allow him to return to the residence with a no hostile contact order.
Is this a PBL state?
I'm not sure, Your Honor.
Could you look that up for me, counsel? Defense, do you know?
I'm 99% sure it's not. I think it's a flat F1, but I want to
Okay.
double check before I misrepresent something.
Pretrial release, anything you'd like to bring to my?
As well, Your Honor.
Thank you.
I believe it's F1 as well.
I think so too.
Yeah, thank you.
Does pretrial release have any, do you know of any other
No, Your Honor.
convictions?
No, he just has no priors.
Okay. All right. At this time, and you live with the alleged victim, sir?
Kids.
I'm sorry?
Yes, these are my kids.
Okay. Ma'am, has anything like this ever happened before?
No, it's not necessarily like this. We had a mixed understanding where my daughter read something in my diary and she reported it, but it was never nothing against the kids or anything like that. And it was all taken care of.
Are you afraid of him at all or afraid for the safety of your children?
Not at all. Not at all.
Okay, at this time, I have found probable cause. In addition, what I am going to do is I am going to set bond in the amount of $1,000. I am going to order that there be no hostile contact with the alleged victim. Based on what I have heard and what I have reviewed, I am going to allow some contact, but absolutely no hostile contact. Do you understand, sir? Okay, in addition, you are to consume, for the time being, no alcoholic beverages and no illegal substances, and you're not to have a firearm. Do you understand? Okay, have a nice day, sir.
Thank you.
Okay, one moment, please, everyone, while I take a look at this warrant. Okay, we're back on the record now. Next case is
Davis.
Vincent Gerald White.
Oh. Your Honor, that's mental health.
I'm sorry?
Mental health.
Is it the wrong person?
That means he was.
Oh.
So if someone's like mental health, medical, or behavior, that's like the reason why they're not like brought to the podium.
Okay, so we'll just reset.
Some judges reset. Some will go ahead and do the IA without the person
By waiving initial appearance?
by essentially like waiving the person's presence and appointing the PD anyway. So-
Okay, at this point, we're going to reset that one. Okay, all right, the next one is Johnny Williams.
We don't have that, Your Honor. Do you have a booking number? They may have bonded.
1025885.
bonded.
Okay, and then just these, okay. Okay, ma'am, you may approach. Good afternoon. Please state your name for the record.
Felicia Davis.
All right, Ms. Davis, you are here for a first appearance. One moment. For the charge of trespass on property after a warning. You have the right to remain silent. Anything that you say may be used against you. You also have the right to talk to counsel and to talk to your friends and family, and reasonable accommodations can be made if you would like to do that. You also have the right to an attorney. At this point, would you like me to appoint the Office of the Public Defender to represent you?
Yes, ma'am.
Okay, so I will go ahead and appoint the Office of the Public Defender. They now represent you in the case. I have reviewed the affidavit, and I do find that there is probable cause. Let's see here. Anything that needs to be brought to my attention from pretrial release?
She's out on bond on 2 cases, on 2 trespass cases.
Okay.
2021 MM 66669AO and 2021 MM 720AO. Sorry.
Oh, the orange ones are, okay. Okay, thank you. One moment, please. Okay, state,
Oh, no position, Your Honor.
defense, would
recommendation.
you like to be heard before I make a decision?
I'd ask for ROR, Judge, and to take no action on the other 2 trespass cases. And I would note that in the 21 MM 720 case, there was a notice of a suggestion of incompetency filed. She has
Okay.
not been adjudicated incompetent, but counsel did raise concerns.
Okay, one moment, please. Okay, so it was at the same, this new law violation is at the same place?
Oh, one moment, Your Honor, let me.
I believe it is. Okay. Okay. I appreciate your concern about the competency issue, and I urge you to file a motion in the event that you deem that that is necessary and appropriate in front of the other judge. In addition, because she is out on a trespass and she's out on bond, and there's probable cause to believe that she has violated those conditions, I'm finding that there are no reasonable conditions I can think of at this time that will ensure compliance and protect the community and the victims. So at this point, I am going to revoke bond on the other charges and hold her at no bond on the new charge. Anything further?
And Your Honor, it was the same place.
Okay. All right. Have a nice day, ma'am.
And Judge, that was, I'm sorry, Ms. Ann. Was that no bond on the 2 out on bonds?
I thought that the 2 add-ons were for the original trespass. So not add-ons, but am I missing something?
No, Your Honor. She's here for new law violation or trespassing,
Yes.
but she's out on bond
Yes,
for 2 other trespasses.
That
But
was
it all
my-
happened at the same place.
that was my understanding. So I revoked bond on the other one and did no bond in light of the violation
So no bond on the violation.
on the new.
No bond on all 3?
Correct.
Okay.
Tell me what the concern is, counsel. I'm willing to listen to you.
So
Should we bring her back in?
we can, I think that the court absolutely has authority to revoke the bonds in the 2 out on bond, but I think she's still entitled to a bond on the new one.
Okay.
Unless the state files a pretrial detention motion because it's its own new case that she's entitled to reasonable conditions on.
Okay. All right, thank you for that. State?
No position, Your Honor. I mean, I would leave it to the discretion of the court. We don't intend to file pretrial detention motion, or at least that determination hasn't been made yet.
Okay, here's what I'm going to do. I'm going to revoke the bond on the other charges. As to the new charge, the bond is going to be set at $500. I need to bring her back, please, and then we need to address another case where this occurred.
Okay, Your Honor.
Hi, ma'am. Your defense attorney just brought something to my attention. At this point, I am revoking the bond on the other trespassing charges. But on the new charge of trespassing, for which I have found probable cause, I'm going to set the bond at $500, okay? In addition, ma'am, you cannot return to the place where the alleged trespassing is alleged to have occurred. You cannot go back there. You can have no contact with the victim. Do you understand that, ma'am?
Yes, ma'am.
You may not return, you may have no contact. In addition, ma'am, you may have no illegal substances. Do you understand that?
No, ma'am.
Okay, so you cannot have any drugs or any illegal substances.
Yes, ma'am.
Okay. All right, thank you, ma'am. You have a nice day.
You too.
Okay. Counsel.
Thank you, Judge.
Well, thank you for bringing it to my attention. And here's my concern. I think that I did that earlier based on my notes. I think that I might have done it in an Osceola County case. State? I think... Does anyone else recall that? Let me look at my...
I vaguely recall that.
I don't remember that.
Okay, one moment. Let me see if I can glean this from my notes.
Okay, it may be Mitchell Gray. I wrote a note that bond was revoked in that case, and that it was no bonded in this case.
Okay, who can pull it up the easiest? I feel like it was an Osceola case.
I think you're right. I think it was.
But if I don't have jurisdiction to do it, I do not intend to do it. So it helps me, honestly, if you all bring these things to my attention. I'm always willing to listen to you. I might not find in your client's favor, but I'm always willing to listen to the arguments. Thank you. Okay, let's see if it was this one.
I don't know if it's based on the charge. Is that what you're saying? Right?
I think so.
I mean, you know what I mean? Because that's just a trespass.
Yeah.
Yeah, right.
Right. Yes. Okay, so it looks like... Okay, and there was no argument. It is a different charge. There was no argument to the contrary. Okay.
And it's weird because even when, it especially gets weird with the domestic ones, because a violation of condition of domestic violence is still entitled to a bond. But if they were out on bond, that one gets revoked.
And I think that's...
I think
okay.
that was the situation.
Okay, let's go to the next case. Thank you, everyone, for your arguments and clarification. Thank you, Madam Clerk. Okay. Good afternoon, sir. Would you please state your name for the record?
Hernandez.
Mr. Hernandez, you are here for a first appearance for the charge of battery and trespass on property after warning. You have the right to remain silent. Anything that you say may be used against you. You also have the right to talk to counsel, family, and friends. And reasonable accommodations can be made if you would like to do so. You also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you today? Okay, so at this point in time, I will appoint the Office of the Public Defender. In addition, having reviewed the arrest affidavit, I am finding probable cause in this case. Is there anything that pretrial release wants to bring to my attention?
Yes, Sharana. He does have an active injunction that expires November 22nd of this month. with the same victim. He does have an active warrant out of Nebraska, but they will not extradite, and that's for a failure to appear for possession of controlled substance.
Okay, but they are not going to extradite.
Correct, Your Honor.
Okay, so there's an active injunction against the same alleged victim. Okay, state?
Nothing from the state, Your Honor.
Defense?
Judge, Mr. Hernandez is asking the court to consider pretrial release or ROR.
Pretrial release?
We can't.
Okay.
Excuse me, ma'am, can I say something?
Would you like to speak to your attorney first?
I was trying to, but I think I can express it a little bit more so you can.
Why don't you take a moment to speak with your attorney, sir?
Judge, so Mr. Hernandez's situation is that he has money to afford a bond that the court would possibly set. However, he doesn't have access to the funds while in jail, hence the reason for asking for pretrial release or ROR. He is willing to provide an address to which he can return. However, I'm not aware of any civil injunction, so I'm going to decline to have him provide anything that could be incriminating because I don't know what's going on in his civil case.
My concern is about the active, unfortunately, I'm not going to grant the request for the pretrial release or the ROR right now. I understand you're concerned about the funds. Nevertheless, I'm not going to do it. One moment, please. I'm concerned about the active injunction and the fact that this would, well, there's not a violation charged.
I do have the case number for that injunction if you need that as well, Your Honor. Let's see.
Okay, at this point, because this is an active, it's alleged to be the same victim or person that there's an injunction for, and because the alleged victim is the same on the battery, I am going to put a bond amount at $5,000. And for the trespass on property after warning, I'm going to keep that at $100. I am concerned about the conditions and whether you would be able to comply with those, given the injunction and the allegations in this case, and in addition, the concern about the community and the alleged victim. In addition, sir, you are to have no contact. Okay, with regard to the property, you are not to return to that property. Is there any, you don't live there or anything like that, do you, sir? Okay, just wanted to verify. In addition, sir, you are to have no illegal substances. Do you understand, sir? Okay, so no contact whatsoever. Have a nice day, sir.
Got a bond?
Your Honor, we
Yes.
have Martin as a refusal.
He's a refusal?
Yes, ma'am.
So he's waiving his initial appearance?
It's up to the court. He refused to come to court.
He refused to come to court. Okay, we'll go ahead and reset him. Okay, the next case, Dominic Natoli,
That's a bond.
out on bond?
Yes, ma'am.
Thank you, ma'am. I appreciate your help. Okay, and then the next case, Ayana Rayner. Ma'am, would you please state your name for the record?
Ayana Reiner.
Good afternoon, Ms. Rayner. You are here for a first appearance for the charge of prostitution. You have the right to remain silent. Anything that you say today may be held against you or may be used against you. In addition, you have the right to communicate with counsel, family, and friends, and reasonable accommodations can be made for you to do that. Further, you have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you today? Okay. At this point, I will appoint the Office of the Public Defender to represent you. I am finding that there is probable cause in this case. Is there anything that anyone needs to bring to my attention?
No, Your Honor. She's returning back to Tennessee when she gets released.
Okay. All right. Defense?
Your Honor, I would make a probable cause challenge.
Okay.
The basis, so she was charged by the officer under 796.072E, which, just because I have it handy, reads, for a person 18 years of age or older to offer to commit or to engage in prostitution, lewdness, or assignation. So my argument is that the police report simply puts offer / accepted, or I forget what the exact language was, but essentially
Look at it now.
To me, the report doesn't make clear whether there was actually an offer.
I'm looking, counsel.
So it says, during this conversation, the defendant agreed / offered.
Okay. And then this, let me just look up the statute number that you're relying on. 796.
Yes, 796, just closed it.
I got it. 796.072. Yep, 2E.
Yeah.
0.07. Okay.
So essentially, the argument is, in the report, he puts agreed / offered, but under the statute, those are two completely different things. And if the officer doesn't actually know which one it is, we can't find probable cause under the subsection that just governs offered.
Okay, thank you for your argument, counsel. I understand what you are telling me. I've reviewed the statute and the affidavit. I still think it's sufficient for probable cause, but you're welcome to bring that motion forward at a later date. In addition, I am going to set a bond amount in the amount, sorry, pretrial release, one more time, I'm sorry.
Your Honor, yeah, she's here from Tennessee. She's returning back once she's released.
Any priors?
She does have a last conviction of possession of marijuana. That was out of state back in 2017. She does have arrest, but the only conviction is the marijuana charge.
That's the only other conviction. Okay, and she is going to return.
Per our notes, yes, back to Tennessee upon her release.
And then how does that work with upcoming court dates?
She will be given the court date. She has to return back to court.
Okay. All right, ma'am, do you understand that even though you might leave Orlando, you do have to return back for your court dates?
They told me last night.
Okay. What I'm going to do now is I'm going to set your bond. One moment, please. I'm going to set your bond at $500, ma'am, but you must return for all court dates. Do you understand, ma'am? Okay. Have a nice day.
Thank you.
Miss,
Yes.
I'm sorry, could Miss Robin tell us if there's any bond pending
No.
on this case? No bond pending? Okay. Just have to wait and see.
Okay, next case, please approach. Would you please state your name for the record?
Rodney Saintville.
Rodney Saintville. Good afternoon, Mr. Saintville. You are here for a first appearance for the charge of let me make sure I'm saying this right. For the charge of trespassing on property after a warning. You have the right to remain silent. Anything that you say may be used against you. In addition, you have the right to speak with your counsel, family, or friends, and reasonable accommodations can be made if you would like to do that. Sir, you have the right to counsel. Would you like for me to appoint the Office of the Public Defender to represent you in this cause?
Yeah, sure.
Okay, at this point, I am going to appoint the Office of the Public Defender to represent you. One moment, please. Okay, at this time further, I am finding that there is probable cause in this case. Pretrial release, anything I should consider before setting bond?
Yes, Your Honor, he is out on pretrial release for a stalking and a trespassing charge.
Is it trespassing on the same property? Do you know?
I'm looking, it's a different property, Your Honor.
State?
Your Honor, I mean, it's my understanding that the defendant was aware that he'd been trespassed from this location, or that he wasn't allowed to be there. I think out of the interest of the.
I'm sorry, what was the last point you made?
Sorry, that it seemed from the report that he was aware that he was not supposed to be there, and that out of the interest of, the safety of the victim here, we would recommend a bond of no less than $1,000.
All right, one moment, please, everyone. Defense? Sorry.
No, Your Honor. I would just ask the court to take no action on the out on bond case.
Okay. At this point, I am going to revoke the pretrial release. So those charges, do I need to set bond on those charges then? Which were,
Okay, so if you're revoking the out on bond, the out on pretrial, okay, so you have to set a bond for the new law violation of the trespass.
right,
Correct, Your Honor.
okay. So for the new trespass, I'm going to set bond at $1,000. My concern, sir, is that you comply with all of the requirements set by the court. Do you understand that? In order to ensure compliance with court orders and to protect the community, I need to make sure that you understand you have to comply with all of the conditions imposed. Do you understand, sir?
Yes.
Okay, so you may not return back to this apartment complex. Do you understand that?
Right.
You may not go back. You may not have contact with the employees there. Do you understand that?
Yes.
Okay. In addition, sir, you are to have no illegal substances. Do you understand that?
Yes.
Okay, have a nice day, sir. Good afternoon, sir. Will you please state your name for the record?
Dylan Steptoe.
Mr. Steptoe, you are here for a first appearance on the charge of contempt of court and violating an injunction of stalking. You have the right to remain silent. Anything you say may be used against you. You have the right to communicate with counsel, family, and friends. And if you would like to do that, reasonable accommodations may be made. In addition, you have the right to counsel. At this time, would you like for me to appoint the Office of the Public Defender to represent you?
Yes, ma'am.
Okay, at this point, I will go ahead and appoint the Office of the Public Defender. In addition, I am finding probable cause is set forth in the arrest affidavit in this case. There was an active injunction at the time of the arrest. Pretrial release, anything?
Your Honor, yes, we did qualify Mr. Steptoe for pretrial release. He has no priors. His mother did verify community ties and residential information.
Okay, and that's notwithstanding an active, is it an active injunction that you see?
I'm pulling that up right now, Your Honor. It says a contempt of court, a violation of injunction, then it has a stalking. Let me just.
Right.
Let me do a little.
State, do you have any ideas, sir?
I'm looking into it right now, Your Honor.
I'm trying to see if he has.
I'm wondering if there's an active injunction in place for this alleged victim.
Give me one moment, Your Honor. I'll get that.
Certainly.
for you. Let's see. All right. Oh.
Yes, Your Honor, it is for this same victim,
I'm
Paige
trying to pull this.
Pugliese.
And it's an active injunction?
Yes.
Counsel, will you mind speaking into your microphone? It's
Yeah,
just hard to
sorry.
hear you with the mask on.
Yeah, sorry about that.
I'm gonna print that out right now, that injunction.
State, do you wish to be heard on that? It looks like there's an active injunction and the allegations are the violation.
And it is with the same victim.
Sorry. Yeah, oh, did I say state? I meant defense. Would you like to be heard?
Yes, Judge, so I'm asking for PTR since he qualifies, but just to be clear procedurally, so he has this civil case, active injunction, and then he's been charged criminally with both violating that injunction and with a new stalking charge. But based on that, I believe he's still entitled to the form of release as to both counts.
Both counts. Isn't there just one count?
It's two, Your Honor.
Yeah.
Okay, one moment. Must be looking at something different. Okay, at this point, given the fact that there is the injunction out and that the victim is the same, my concern, sir, is you have to comply with the conditions imposed by the court. Do you understand that?
Yes, ma'am.
Okay. At this point, I am going to set bond for the violation of the injunction at $5,000. And then as to stalking, I'm going to set bond, one moment, please, at $2,000. Sir, you may have absolutely no contact with this victim. Do you understand what I'm saying? That includes text messages, phone calls, in-person contact, social media, any other form of contact I have not thought of today. Do you understand no contact?
Yes, ma'am.
Okay. In addition, sir, you may have no firearms and you may have no illegal substances. Do you understand, sir?
Yes, ma'am.
Have a nice day, sir.
I never knew that.
Yeah.
Okay. Sir, would you please state your name for the record?
Euterius Bryant.
I'm sorry?
Euterius Bryant.
Uh-oh. Okay, one moment, please.
What happened with, Cedric?
Alcindor?
You have a booking number, Ian?
2102-5878.
We don't have it.
Thank you.
Right?
He bonded. Yeah.
All right, sir, would you please state okay, you're Mr. Bryant, yes?
Yes.
Okay, thank you. Good afternoon, Mr. Bryant. You are here for a first appearance on the charge of violation of probation. The original offense, it looks like, was petty theft. At this time, sir, you have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, with your family, and with your friends, and reasonable accommodations can be made to let you do that. You also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you today?
Yes.
Okay, at this point, I will appoint the Office of the Public Defender. I am finding that there is probable cause to support the charge of violation of probation. State,
No recommendation from the state, Your Honor.
pretrial release, anything?
No, just that he does have an open case in Seminole County for a traffic catch and tag.
Okay. Defense?
Judge, we're asking for a reasonable bond on this. I looked at his violation affidavit, and it looks like the only allegations are failure to complete community service hours and payment. Additionally, he is not a violent felony offender of special concern, and the underlying charge is grand theft, for which he received a withhold of adjudication. So we're just asking for a reasonable bond.
Am I correct that he's not entitled to a bond under the law because it's a violation of probation?
That's correct.
Okay. All right. At this point, I am going to set no bond. I appreciate your arguments on his behalf, counsel. I am going to set no bond in this case. Anything further that needs to be addressed?
No, Your Honor.
Okay. Have a nice day, sir. Okay, the next case. Please state your name for the record, ma'am.
Jasmine Butler.
Ms. Butler, good afternoon to you. You are here for a first appearance on the charge of violation of probation. It looks like the underlying offense is alleged to be grand theft in the 3rd degree. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with counsel, family, and friends, and reasonable accommodations can be made if you would like to do so. You also have the right to an attorney. If you do not have an attorney, I can appoint the Office of the Public Defender to represent you today. Would you like me to do that, ma'am? Okay, at this point, I am going to appoint the Office of the Public Defender to represent you. I have reviewed the new arrest affidavit, and I am finding that there is probable cause to support the charge. Sorry, I'm just looking at something. Are there 2 cases?
Yes.
Okay. Okay, there's another violation of probation in case number 2020 CF 006281. You'll also have the Office of the Public Defender for that. That is also a violation of probation and the underlying charge, and that was uttering the forged check. I am finding probable cause to support both charges. I do see that you are on probation, so these are both violations of probation. I'm going to set them at no bond.
The second case, that's 5,000.
Where is that? Let me see. One moment, please. Second case. Is it a capias? Let's see. Oh, they did it. Okay. Okay. It looks like, as to the second case, and for the record, let me just get clarity here. For the record, that's the case number ending in 6281. That violation of probation does have a bond amount that was set at $5,000. So I will leave that bond amount on the second case. The first one, I'm entering no bond.
And Your Honor, she's also out on bond on 2021 CF 11538AO for a grand theft.
So Judge, I believe.
Is that the first one? That's the first one, or is that a different?
No, this is an open case. This is not a new law violation. She's out on bond for a grand theft.
This is a third. Okay. Okay, so I am going to,
Judge,
yes,
if I could, before
Yes.
you rule, the grand theft that she's out on bond for, that's what violated her probation. So she has the VOP because she was arrested for the grand theft. So what I believe happened was she immediately bonded for the grand theft before anybody realized she was on probation, and then the VOPs hit. So then she got arrested again. So I don't think we can revoke. I don't think you can should revoke her bond on the grand theft because that's what caused the VOP.
that's what caused the VOP. Okay.
Does that make sense? So usually they would all
Yes.
come in together because there's a hold, but sometimes DOC just like misses it, and she was able to just bond out real quick before going to court.
Okay.
That's what I think happened, but.
Pretrial, you want to be heard on this?
No, I was just trying to read those conditions of the other violation of probation. Usually if that's the case, we don't, but she, like the PD says she bonded out, but I'm just trying to find the conditions of the other VOP.
State, do you have anything?
Nothing from the state, Your Honor.
All right.
Because the jail paperwork.
Yeah.
Under the 21 case says this case violated. So I don't know.
Oh, one moment, let me 20, let me just look at. Let's see, 722, let me just collect on the.
So it looks like the first what?
Yeah, 722. I'm just looking, Your Honor.
That's the $5,000 one that Judge Strobridge. Let's see, is this? Well.
Okay, so she came in on a warrant September 29th for that 2021 CF 11538. She bonded.
She came in on the charge of third degree of grand theft, correct?
Your Honor, full warrant September 29th on that case. 11538.
And then put on probation?
So she's been on probation for,
Maybe.
a while. And what usually happens is when someone gets a new law, they do like an on view, like, oh, you're on probation, we're gonna violate you now. And then she just stays in jail. But this time, for whatever reason, she was allowed to bond. And then 2 weeks later, the actual VOP warrant hit for this grand
It's the
theft.
same one.
Yeah, and then she just got picked up on it. So she didn't actually commit a new law while out on bond for the grand theft.
State, you don't know about this one?
And just to be sure,
Are you prosecuting this as a VOP?
the grand theft third degree, it doesn't look like we have it filed as a VOP. But the other ones, we do have them as VOPs, though. The grand theft Yeah, the uttering forced checks, we do have those as violations of probation. So it's a VOP for the grand theft of the third degree and VOP for uttering a forced check. But for the grand theft, we just have that as a grand theft, not as a VOP.
Okay. All right, counsel, I appreciate your arguments. Go ahead and bring those to the next judge. I'm keeping my order entered as it is for now, until we can get some clarity on this. Yes.
You have to get your bond back on this.
But she does have bond on that second one. Right. Right. But that's the one that they're challenging. Go ahead, Mr. Donnelly.
Sure.
Right.
Because
It's on the third. I'm okay, let's get her back.
I know she's no bond on the VOP. Yeah, it's just for the third one.
Okay. Okay, so on that one, then I'll go ahead and set the bond at the 2,500.
Okay, she's on my bond for you?
She's out on bond on that for 2,500, correct?
Okay.
So I will not revoke that at this time.
Okay, no action. Okay.
You're taking no action then?
Correct.
Thank you, Judge.
I apologize. And I got confused with
No,
the
no.
two being the same.
Perfect. Oh, I was that back.
Have a nice day, ma'am. At this time, I'm leaving the bond on the other case.
Cool. So you're good. Yep, we'll just address the one. Thank you, Judge.
Thank you, counsel. Sir, will you please state your name for the record?
Christopher Donnelly.
Mr. Donnelly, you are here for a first appearance today for the charge of violation of probation. The original offense looks to have been a DUI. You have the right to remain silent. Anything you say may be used against you. You also have the right to speak with counsel, friends, and family, and reasonable accommodations can be made to let you do that. In addition, you have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you today? Okay, I will do that and go ahead and appoint the public defender to represent you. In addition, I am finding probable cause based on what I have reviewed. One moment. Yes, based on what I have reviewed. In addition, probable cause, it looks like was found by Judge Bleckman as well. At this point, given that it's a violation of probation, is there anything anyone wants me to consider?
Nothing from the state, Your Honor.
Yeah. Judge, Mr. Donnelly would like for me to advocate for a bond based on the circumstances of his violation of probation. But in candor to the court, I believe I have to acknowledge a prior conviction on the paperwork here that would be a disqualifying offense under the statute.
I'm sorry. I'm currently a patient in the Salvation Army Adult Rehabilitation Center. Only thing is, I have no family out here, no money, no job. They're my family. So I'm there, been over there a month and a half. If I get there by Monday, I still got my bed, clothes, shelter. It kind of was a big misunderstanding with the PO. I went and seen him October 5th. This wasn't even brought up. I was in rehab September 30th. The warrant didn't get dropped till October 23rd. I'm just down here trying to do the right thing. Work, group, church, meetings, and work therapy at Salvation Army, and this happened. As I was taking a pass from the Salvation Army to go see him, I'm baffled, actually.
Okay.
Thank you.
All right, thank you, sir. I appreciate your comments. Counsel, I appreciate your arguments. At this time, given what I've reviewed and the nature of the charges, I am going to find no bond. Have a nice day, sir.
All right, thanks.
Good afternoon, sir. Would you please state your name for the record?
Dwayne Alonzo Graham Jr.
Mr. Graham, you are here for a first appearance on the charge of violation of probation. The underlying charge was grand theft. You have the right to remain silent. Anything you say may be used against you. You also have the right to communicate with counsel, family, and friends, and reasonable accommodations can be made if you would like. In addition, you have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you at this time?
Sure. Thank you.
Okay. At this, you said yes?
Yes, ma'am.
Okay. At this point, I will appoint the Office of the Public Defender to represent you. One moment, please. Okay, I am finding that there is probable cause to support the violation of probation. In addition, that was previously found by Judge Young. Is there anything that anyone wishes to bring to my attention?
No, Your Honor.
For that VOP, there's a 5-day hold in place.
There's a 5-day hold.
It's on a violent felony of special concern.
Okay.
So we put the 5-day hold in place and we give DOC time to bring the warrant. But he's also here on a battery on a law enforcement officer resisting and a petty theft. He's here on another case as well, Your Honor.
Okay, and it's a VOP.
2 different cases.
Yeah, I'm really bad at finding that second one, aren't I? Goodness. Okay, sir, oh, I'm sorry. Civil law. So it's interesting that it's not charged. No, this isn't.
I know.
Nothing from defense, Your Honor.
Okay. At this point, given that it's a violation of probation, I am going to set it at no bond. In addition, though, sir, you're here on case number 2021 CF 0143540. And those offenses for which you're here for a first appearance are battery on the law enforcement officer, the resisting an officer with violence, and the petty theft. You are still represented by the Office of the State Attorney. One moment, please. Oh, probable cause was already found on this as well by Judge Young. Oh. Why do I keep doing that? It's a lot. Okay. There's so many.
No. That's okay.
Did you want to bring something to my attention?
I'm sorry.
No, Your Honor, he was just a little confused by the 5-day hold, so I just explained it. We're good.
Okay. All right. On the other charges, I am going to set bond, and it looks like there are conditions that were previously imposed. And so on count 1, I will set bond at $150, on count 2 at $1,000, and on count 3 at $150. In addition, the conditions are that you are not to return to the location of the alleged offenses, and you can have no contact with the alleged victims or its employees. Do you understand that? Okay. Let's see. In addition, I'm going to require that you have no firearms and no illegal substances. You understand?
Yes, ma'am.
Have a nice day, sir. Okay, and sir, would you please state your name for the record?
Sean Hamilton.
Mr. Hamilton, you are here for the first appearance of the charge of violation of probation. The underlying charges are of lewd and lascivious battery and lewd and lascivious exhibition, excuse me. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with counsel, to speak with your friends or family, and reasonable accommodations can be made if you would like to do that. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you in this cause? Okay, so at this point in time, I will appoint the Office of the Public Defender to represent you. One moment, please. Let me just make sure. Okay, at this point, I am finding probable cause to support the charge. Is there anything that the defense would like to bring to my attention?
No, Your Honor.
Okay. At this point, I am going to set it at no bond. Have a nice day, sir.
I'm sorry, Your Honor. I might have missed it. Are both cases no bond?
Well, I didn't see a second.
Oh, it was add-on. Oh, okay, never mind.
It's like I looked for that. Okay. Sir, would you please state your name for the record?
St. Pierre.
Mr. St. Pierre, you are here for a first appearance of the charge of a violation of probation. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with counsel, family, and friends, and reasonable accommodations can be made if you would like to do that. You also have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you at this time?
I have a lawyer.
Is your lawyer here today, sir?
No, I hired him yesterday.
You hired him yesterday. And I don't believe that we have anyone on the line. Let's see.
Let me call when I get back to the dome. I'll call home and I get that situated.
Okay, since he's not here today, sir, would you like for the Office of the Public Defender to represent you just for today?
Yeah, just for today.
Okay, I will go ahead at this time and appoint the Office of the Public Defender to represent you. At this time, I am finding that there is probable cause. Is there anything that the defense would like me to consider?
Not at this time, Your Honor.
State?
Nothing from the state.
Okay. At this point, I'm going to set it at no bond. Have a nice day, sir. Sir, would you please state your name for the record? Mr. Anzalone, you are here for your first appearance in the charge of having an alcoholic beverage in an open container. One moment, please. I'm just looking through this top. Okay, it looks like he was also charged with driving under the influence. Is that correct?
Yes, he's out on PTR for DUI, Your Honor.
Okay, he's out on PTR for a DUI. Okay, sir, you've also been charged with the crime of driving under the influence. Okay, you have the right to remain silent. Anything that you say today may be used against you. You also have the right to speak with your attorney and with your friends and family members, and reasonable accommodations can be made to help you do that. You also have the right to an attorney today. Would you like me to appoint the Office of the Public Defender to represent you? Okay, at this time, I will appoint the Office of the Public Defender to represent you as to the charge of, one moment, please, as to the charge of alcoholic beverage containers, an open container of alcoholic beverage. I am finding probable cause. Is there anything that the defense would like to bring to my attention before I set bond?
Just that he has very little history, Your Honor. And by very little, I mean, according to this, one conviction for possession of less than 20 grams of marijuana in 2016.
But he's out on pretrial release right now, correct?
Yes, Judge.
For that?
Correct.
For DUI.
Then he had a conviction out of state for DUI in the open container. Let me pull it up. Give me time.
I'm sorry, sir. Go ahead and talk to your attorney and then she can talk to me. State, are you taking a position on this?
No, Your Honor.
Does the state think it's appropriate to revoke pretrial release or keep pretrial release?
I mean, I'm leaning towards it being appropriate since there does seem to be a problem with alcohol for this particular, for Mr. Anzalone. But I would still leave it in the discretion of the court. Frankly,
Defense.
our office doesn't, our office probably won't prosecute this, I'll be frank with you. But again, it is my view that there does seem to be a problem with alcohol for Mr. Anzalone, but again, I would leave it in the discretion of the court.
And Jan, I can answer his question. He was arrested back in 2019 in Texas for carrying a weapon, and he had driving while intoxicated, open alcohol container. Date of offense, May 12th of 2019. He was released on his own recognizance.
And Judge, if the court is inclined to revoke PTR, I would just ask that a bond be set on the DUI, given that this was a city ordinance violation. I understand it's alcohol, but he wasn't driving.
And I'm sorry, Your Honor, I don't mean to interrupt. I'm just going back to that. Then he finally was pled guilty for the DUI, and it says probation discharge, September 17th of 2020. So I don't know if he was given the opportunity to go on probation and they didn't do it, or if he's on probation, that's the status.
Is that for the charge where you're saying he's on the PTR for?
No, this was out of state.
That was out of state. Okay. Do you all typically recommend that PTR stay in place?
That's your discretion, Your Honor.
Certainly, I understand.
But I don't know about this probation thing out of state, so I have no idea. It's your discretion.
Probation is out of state, but that's not in front of me, right?
It may be a possibility that he is. I just don't understand how they just have probation discharged. I don't know what that means.
Okay. Okay, but if it's my discretion, then he still does qualify for the PTR on the other, on the DUI?
I mean, if you want to keep it at the DUI or revoke it or give him a bond.
Sure, I understand. Okay. All right, at this time, I am going to revoke the PTR. I am going to set a bond. One moment, please. The bond for the open container will be set at $250. Oh, geez. One moment, please. One moment, please. I'm just looking for my schedule. Do I have a bond schedule in here? One moment, please, sir. In addition, sir, as to the conditions, while my computer's loading, as to the conditions of the bond, I am going to order that you have no illegal substances and that you have no alcohol at all. Do you understand that, sir?
Yes, ma'am.
Okay, one moment.
Hold on. Judge, I have a schedule. Were you looking for the DUI or?
Yes.
Okay. I think it's 500, but I don't.
My computer's not working.
My hands are a lot slower than control.
I know. I understand.
Okay, so first DUI first offense is 500. Second offense 1,000. I don't think third offense applies here. Right?
Okay. All right, at this point, I'm going to set bond in the amount of $1,000, and the same conditions remain. You are to have no alcohol and no illegal substances. Do you understand, sir? Yes. Have a nice day, sir.
Here, take this. Oh, sorry.
Good afternoon, sir. Would you please state your name for the record? Okay, Mr. Lewis, you are here for a first appearance on the charge of possession and consumption of alcohol prohibited in public. You have the right to remain silent. Anything that you say may be used against you. You also have the right, sir, to speak with your counsel, with your friends, or with your family, and reasonable accommodations can be made to allow you to do that. You also have the right to an attorney today. Would you like me to appoint the Office of the Public Defender to represent you?
Yes.
Okay, at this point, I am going to appoint the Office of the Public Defender to represent you.
Judge, I believe the state has no objection to ROR.
I'll confirm that, yes.
Okay. All right, hearing no objection, I am finding probable cause, and then we'll release him on ROR. Have a nice day, sir.